Judgment in the matter of the Trustees of the Barry Congregation of Jehovah's Witnesses against BXB.
Lord Burrows will explain the decision of the court.
The court has made an anonymity order in this case, by which it is ordered that no one shall publish or reveal the name or address of the respondent, or publish or reveal any information which would be likely to lead to the identification of the respondent or of any member of her family in connection with these proceedings. This case is concerned with vicarious liability, which is an unusual form of liability because the defendant is held liable not because it has itself committed a tort, that is a civil wrong, against the claimant, but because a third party has committed a tort against the claimant. Traditionally, vicarious liability was essentially confined to where an employee committed a tort in the course of his or her employment. Where that occurred, the employer would be held vicariously liable for the tort of its employee. But that relatively clear and well-settled picture of vicarious liability has been redrawn and expanded over the last 2 decades, primarily to deal appropriately with claims for sexual abuse of children. In this case, the question at issue is whether applying the modern law on vicarious liability, the Jehovah's Witness organisation should be held vicariously liable for the rape of a 29-year-old married woman, who I shall refer to as Mrs B, by an elder of the Jehovah's Witnesses, Mark Sewell. Mrs B and her husband began attending the services of the Barry Congregation of the Jehovah's Witnesses in 1984. They made lots of friends in the congregation, among whom were Mark Sewell and his wife Mary Sewell. Mr and Mrs B and the Sewells became very close friends. Indeed, Mrs B considered that Mark Sewell became her best friend. Towards the end of 1989, Mark Sewell began to abuse alcohol and appeared depressed. Around the same time, Mrs B stated that Mark Sewell began flirting with her, including hugging her, holding hands, and kissing her. He was also confiding in her. Mrs B was so concerned about his behaviour that she spoke to Mark Sewell's father, Tony, who, like his son, was an elder. Tony explained that Mark was suffering from depression and needed love and support. On the morning of the 30th of April 1990, Mr and Mrs B and Mark and Mary Sewell took part in door-to-door evangelising. Afterwards, they all went to a local pub for lunch. Mark drank beer and wine. He argued with his wife, and she threw a glass of whiskey over him. Mark stormed off. Later that afternoon, Mr and Mrs B went to Mark and Mary's house with their children. At some point, Mrs B enquired about Mark's whereabouts. Mary said that he was in the back room and asked Mrs B to see if she could talk some sense into him. Mrs B decided that she should go to speak to Mark to try to convince him that he should go to the elders about his depression. A conversation ensued, during which Mark Sewell pushed Mrs B to the floor, held her down, and raped her. On the 2nd of July 2014, Mark Sewell was convicted of raping Mrs B and of 7 counts of indecently assaulting 2 other individuals. He was sentenced to 14 years imprisonment. Following the rape, Mrs B suffered episodes of depression and post-traumatic stress disorder. In 2017, she commenced an action for damages for personal injury, including psychiatric harm, against what I'm referring to for shorthand as the Jehovah's Witness organisation, alleging that it was vicariously liable for the rape, that is, the tort of trespass to the person, committed by Mark Sewell. Her claim succeeded before Mr Justice Chamberlain, and his decision that the Jehovah's Witness organisation was vicariously liable for the rape was upheld by the Court of Appeal. The Jehovah's Witness organisation now appeals to the Supreme Court. The Supreme Court unanimously allows the appeal. The judgment is given by myself, with whom Lord Reid, Lord Hodge, Lord Briggs and Lord Stevens agree. In applying the modern law of vicarious liability, there are two stages to the inquiry. Stage one is concerned with the relationship between the defendant and the tortfeasor, that is, the person who commits the tort. Stage two is concerned with the link between the commission of the tort and that relationship. Both stages must be addressed and satisfied if vicarious liability is to be established. The correct test at stage one is whether the relationship between the defendant and the tortfeasor was one of employment or akin to employment. The Supreme Court agrees with the lower courts on this issue. Although an elder is not paid, and Mark Sewell was not an employee of the Jehovah's Witness organisation, the relationship between the Jehovah's Witness organisation and Mark Sewell in his role as elder was akin to employment. The important features here rendering the relationship akin to employment were that as an elder, Mark Sewell was carrying out work on behalf of and assigned to him by the Jehovah's Witness organisation, that he was performing duties which were in furtherance of and integral to the aims and objectives of the Jehovah's Witness organisation, that there was an appointments process to be made an elder and a process by which a person could be removed as an elder, and that there was a hierarchical structure into which the role of an elder fitted. The test at stage two of the vicarious liability inquiry is whether the wrongful conduct was so closely connected with acts that the tortfeasor was authorised to do that it can fairly and properly be regarded as done by the tortfeasor while acting in the course of the tortfeasor's employment or quasi-employment. In the view of the Supreme Court, disagreeing with the courts below, the claimant fails to satisfy this test at stage two for several reasons. First, the rape was not committed while Mark Sewell was carrying out any activities as an elder on behalf of the Jehovah's Witness on behalf of the Jehovah's Witnesses. Secondly, in contrast to the child sexual abuse cases, at the time of the rape, Mark Sewell was not exercising control over Mrs B because of his position as an elder. It was because of her close friendship with Mark Sewell and because she was seeking to provide emotional support to him, and not because Mark Sewell had control over her as an elder, that Mrs B went to the back room. The driving force behind their being together in the room at the time of the rape was their close personal friendship, not Mark Sewell's role as an elder. Put another way, the primary reason that the rape took place was not because Mark Sewell was abusing his position as an elder, but because he was abusing his position as a close friend of Mrs B when she was trying to help him. Thirdly, contrary to counsel for the claimant's submission, it was unrealistic to say that Mark Sewell was always wearing his, quote, metaphorical uniform, end of quote, as an elder in his dealings with members of the Barry congregation. Fourthly, while Mark Sewell's role as an elder was a but-for cause of Mrs B's continued friendship with him, and hence of her being with him in the back room where the rape occurred, but-for causation is insufficient to satisfy the close connection test. Fifthly, what happened in this case was not equivalent to the gradual grooming of a child for sexual gratification by a person in authority over that child. The violent and appalling rape was not an objectively obvious progression from what had gone before, but was rather a shocking one-off attack. Finally, the role played by Mark Sewell's father and the failure of the Jehovah's Witness organisation to condemn Mark Sewell's inappropriate kissing of members of the congregation when welcoming them were not relevant except as background. For these reasons, the conclusion of the Supreme Court is that the rape was not so closely connected with acts that Mark Sewell was authorised to do that it can fairly and properly be regarded as committed by him while acting in the course of his quasi-employment as an elder. As a final check, if one stands back and considers the policy of enterprise liability or risk that may be said to underpin vicarious liability, that confirms that there is no convincing justification for the Jehovah's Witness organisation to bear the cost or risk of the rape committed by Mark Sewell. Clearly, the Jehovah's Witness organisation has deeper pockets than Mark Sewell, but that is not a justification for extending vicarious liability beyond its principal boundaries. The Jehovah's Witness organisation is therefore not vicariously liable for the rape committed by Mark Sewell, and the appeal is allowed.
The court will adjourn.